Hi, and welcome to this first clip of a series of videos that I will create for my introductory course on public international law at University College Roosevelt in spring 2024. These videos will serve as a general introduction to various topics, most notably, on the one hand, the principles, the general principles of international law. We will also look at some of the domains in which international law applies, and finally at the politics of international law. In these videos, I will also answer reading questions, which you can find in the notes to these videos below, and which are based on a textbook by young Klabbers and the specific chapters that cover the topics that I am discussing. As said, this first part deals with the general principles of international law. This means that we will take a legal, doctrinal, what one might call a positivist approach to understanding how international law as a legal system operates and what, for example, distinguishes it from domestic national legal systems. The first and most important topic in this regard, of course, are the sources of international law. So what I will do here in these first three videos, I'll firstly give you some idea of the foundational principles, so to say, the pillars of the source doctrine in international law. I will then move on to talk about customary international law, and finally about general principles of international law, understood as a source of international law, as well as other legal sources. This means that for the moment I will bracket the question of treaties, which I will cover in the next session and in three separate videos dealing with treaties in general, but also with reservations and treaty interpretation. So why do we start off this video series with the topic of sources? Well, in order to understand how international law is applied, whether it is effective, whether states comply, in order to answer all these relevant questions, we need to first know what the international obligations actually are to begin with. So this is where source doctrines and the question of sources gives us an answer. And before we get to how this works at the international level, it is useful actually to firstly remind ourselves of how this works at the domestic level. Well, here, as we all know, Parliament, sometimes to a unicameral system, sometimes to a bicameral system, anyway, regardless of how it specifically looks, there will be a legislative process in which the legislator then passes acts that are recognized throughout the jurisdiction, throughout the country as law. Well, as you probably know, international law does not work in this way. We don't have a global parliament that passes acts of international legislation that are then applied throughout the world. Instead, we have a horizontal system composed of primarily states, which then together decide what counts as international law. And here it's then useful to introduce these twin foundational principles that underlie each and every international legal obligation. The first of these is the principle of state consent. And as is already indicated by the name, what this means is that international law only exists if states have given their specific consent to being bound by a particular rule. This is the consequence of the principle of state sovereignty, which is another foundational pillar of international law. But it is really important to understand that if there is no state consent, if we do not either explicitly or, as we'll see in a second video, implicitly through customary rules, if states have not given their consent, then we cannot speak of international legal obligations. The second principle, the flip side of the state consent principle, so to say, is the notion of Pacta sunt servanda, which is a Latin phrase that can be translated roughly as agreements must be obeyed. And if you think about the notion of state consent, this Pacta sunt servanda principle is the logical corollary of this, because if you would give your consent, but then you would actually not live up to your promises, well, then the whole notion of state consent, the whole notion of agreeing to be bound by something would be completely worthless. Working in tandem, these two principles then show us, on the one hand, what counts as international law, what amounts to an international legal obligation, and on the other hand, they also give us the reason as to why these obligations should be respected. Now, there are a few consequences that arise from the system being set up and constructed in this way. The first one is that international law is a generally permissive system, in the sense that states are free to do whatever they like unless they have specifically consented to an obligation. Now, there are a few exceptions to this. One is the notion of jus cogens, which I will cover in the third clip, but another one that I want to specifically mention here is the jurisdiction of other states. So if actually an action by a state impinges upon the sovereignty, impinges upon the jurisdiction of another state, then that would be potentially also in violation of international law. So the limits of state sovereignty are in fact the sovereignty of other states, and this is also something that we need to keep in mind, and something that we will discuss next week when we discuss the notion of jurisdiction and how jurisdictional rules and principles apply. Having understood these general principles, then another important question comes up. How do we know that a state has consented to a specific obligation? Well, and this is where the idea of sources and source doctrine comes in. If we look at Article 38 of the ICJ statute, and the Klabbers textbook very nicely explains that this is not actually legally binding upon states, but more reflective of what generally the practice is regarding the sources, there are three types of primary sources. First, treaties, also referred to in the ICJ statute as international conventions. Secondly, rules of customary international law. And thirdly, the general principles of international law. There are also subsidiary sources, as the ICJ statute states, most notably judicial decisions and the teachings of the most highly qualified publicists, so basically academic discussions and treatises. These, however, are only helpful and applicable insofar as they illuminate, insofar as they tell us something about the first three types of sources. So they do not stand alone, and this is why, of course, they are referred to as subsidiary sources. This covers the first video. I will now move on to the second type of sources, namely international custom, customary international law rules, before then moving on to the third type.